Good evening and welcome to Legal Talk, the talk show brought to you by the law offices of O'Donnell, Weiss, and Megay. We're at 41 High Street in Pottstown. We're at 347 Bridge Street in Phoenixville. Our phone numbers are 610-323-2800 and 917-9347. Sorry about that. Our website is owmlaw.com, owmlaw.com. And your business, your life, your law firm. I'm Dave Megay. I'm one of the attorneys at the office, and tonight I'm joined by Jim Kovaleski.
Hi, Dave.
Jim, thanks for joining us, and sorry for botching that whole introduction. But folks, tonight Jim and I are going to talk about investment real estate, buying properties for the purpose of renting them out, creating some rental income, some relatively passive income. We'll talk about some of the pitfalls and some of the pros and cons of a couple of different approaches. And Jim, I thought what we do in the first half of the show is remind our viewers about the different types of corporate entities that are out there.
Sure.
Specifically as they apply to owning real estate. And then the second half of the show, we'll talk about the consequences of buying a property in one of those corporate names. And folks, if you have rental properties and you and your spouse own it, or perhaps you own it yourself, we'll talk about the pros and cons of flipping, if you will, or transferring ownership of those properties into the corporate name. Okay, so I think that's a good division of labor there, Jim, or a good way to allocate the time that we have tonight.
Absolutely.
Now, Jim, tell us again. I say again because I know you and I have done some shows. I know me and myself and some other attorneys have done some shows on the different corporate entities. But give us a quick thumbnail, maybe not so quick thumbnail sketch of the different options that our viewers have for corporate entities in the context of purchasing a rental property.
Sure, absolutely. There's actually several different types of options out there, and this, I think, applies to those individuals that are going to be buying a residential unit to be renting to the tenants, or even if you're a small business owner and you're purchasing property that you're then going to rent to yourself, quote unquote. I think this discussion is relevant in both of those scenarios. But so you start off with, before we get to the corporate entities, you own it by yourself. So you own it as a sole proprietorship. You don't need to do anything. You just buy it in your name, or you buy it in more than one person's name, and then you form a general partnership. So those are the two non-corporate entity types that you can basically own a piece of property in. Leaving out some of the more esoterics like a trust owning it and things like that. Getting into the corporate entities, there's as I mentioned a moment ago, there's a couple different options. You'll oftentimes see limited partnerships. So a limited partnership is comparable to a general partnership, except that it provides some liability protection that the general partnership doesn't. So if Dave, you and I go in and buy a piece of property in our names, we formed a general partnership. We're both on the hook. We both have a lot of liability related to that piece of ground.
And by on the hook, you mean we're both personally responsible for the debts associated with that ground, the liability associated with the apartment complex that we just bought.
Exactly. All the good,
That's
bad.
a general partnership.
That's a general partnership.
Okay.
So the limited partnership that I was just mentioning a moment ago, you have limited partners that are not on the hook. They don't have that personal liability, generally speaking, unless they sign like a guarantee, which is another document we can talk about in the second half of the show. But you have limited partners that are not responsible, and then you have one or more general partners. The general partners get a lot of benefits. They get to make all the decisions with regard to the limited partnership, but they also have a lot of liability because they're the one that's going to be personally liable to sign the notes, sign the contracts. If something happens and the limited partnership gets sued, they're going to be personally named in that complaint. The way around, or the way we structure those limited partnerships then, is we form another entity, be it an LLC or an S corporation, to be the general partner, so that liability is then the only entity that's subject to it is that LLC or the corporation, so that we try and prevent personal liability of the underlying shareholders or members of that entity. The real reason, or the big reason that you'll see a lot of limited partnerships in Pennsylvania, and it's Pennsylvania is kind of unique in this, in that limited partnerships own a lot of real estate, is because of the capital stock and franchise tax. It's a state tax. To be honest with you, I don't know how it works. I've had many conversations with accountants. They know how it works, and they know that there's potential times when you buy and sell real estate where you can incur a large capital stock and franchise tax. That's why you'll see a lot of limited partnerships, particularly for larger pieces of ground, more valuable pieces of ground, because the tax stakes get higher as that value gets higher. So that's probably the number one preferred you'll see for owning real estate.
What is a limited partnership?
Limited partnership, if you're going to choose a corporate entity.
Okay, before you go into because you were about ready to go into another one.
I was.
Tell me again how that limited partnership works. I form a corporation.
You form a limited partnership.
Well, okay, form a limited partnership, but the general partner is a corporation.
Or an LLC that we form, yes.
Okay.
Usually done at the same time.
And then the individual investors or the individuals interested in the property are then limited partners?
Yep. So to take my example where you and I were general partners owning a piece of real estate, instead we want liability protection and we want that tax benefit that I had talked about a moment ago.
Okay.
So you and I form a limited partnership, and then we form an LLC to be the general partner. We own 49% of each as limited partners of the limited partnership. The LLC we form is a 1% member. My math's wrong. 2% general partner, and then we each own 50% of the LLC. The net result is that we still own 50% of the property when you follow those all the way through.
Right.
But you and I are not personally liable if something happens on that property or for the loan, because it's the entities, the limited partnership and the LLC that would be liable. Unless, like I said, we offer a personal guarantee.
Okay, well, that'd be a lot better than just you and I buying the property in our own individual names, because then we're both 100% liable. If the property, if someone gets hurt at the property, or there's a contractual debt, I have to pay 100%, or you have to pay 100%.
Absolutely.
But if instead of us just doing a basic cheapy partnership, we do a limited partnership. You and I form a corporation. That corporation is the general partner, say 1% owner, to do a little bit better math. And then you and I are each 49.5%.
Exactly.
Limited partners. Then what happens? How much liable are you and I individually to that same contractual debt?
Our liability is generally limited to whatever our investment has been in forming those entities and the money that we put in upon acquiring those entities. So we can't go. So if we've each put in $10,000 essentially to buy that property to form those entities, that's what our liability is limited to. And the point is, and I guess I jumped in before I made this point, the whole purpose of owning real estate in an entity, the biggest benefit is the liability, personal liability protection that you can generate or have by that ownership structure.
Okay, so we talked about owning real estate in individual names.
Yep.
In a partnership name, you and I individually. And then we just talked about limited partnership name, and you mentioned there was a couple others.
There is. Two other ones. Probably if limited partnership is the number one way to own property, the number two way you'll see, and it might be 1A, 1B, would be an LLC, limited liability company. Probably 25, 30 years ago, before the LLC was around, it would have been just a corporation. But LLCs came into play in Pennsylvania about 25 years ago. They're more user-friendly, to use the term that I've often heard them described, than a corporation. So you'll see a lot of real estate purchased in the name of an LLC. You get that liability protection that we've been talking about that you get with limited partnerships. What you don't get is some of the beneficial tax treatment, because LLCs, even though they're not corporations, they're subject to that capital stock and franchise tax. So potential for a tax hit at some point. But I'll still see clients that want to use the LLC because maybe it's a less valuable piece of property, so that the tax hit won't be as great. So $50,000 piece of property versus a $5 million piece of property. Also, they want the convenience of not having two entities, because with the limited partnership, you have that, and then you have the LLC that acts as the general partner. So there's two entities to maintain, whereas with the LLC or with the corporation, it's only one entity.
Okay, so the limited partnership sounds to me like it's the best way to own real estate, But you just mentioned something a second ago. It's going to be a little more expensive to form and maintain.
Absolutely.
Because you have the limited partnership as an entity, and inside that limited partnership is the general partner, which is a corporation. So you have two entities to form and maintain. I mean, it's not rocket science, and it's not ridiculously expensive, but it's a little more than otherwise.
Oh, absolutely.
And then if the parties didn't want to do a limited partnership, if they're looking to just buy like a 1 unit or 2 unit rental property, then maybe an LLC or corporation form.
Absolutely. Corporation, very similar to the LLC, same concept. You're forming it for the personal liability protection. You just have some additional requirements that a corporation has as far as having a board of directors, officers, having an annual meeting that an LLC is not necessarily subject to. So that's why you've seen the switch over in the last 25 years or so, that more and more people are using LLCs versus that corporation for both owning real estate, operating their business, and various other reasons.
Okay. And if I'm a single person, are you going to push me or recommend me to form either the limited partnership or an LLC? If I'm a single person?
Absolutely.
Because all my assets are exposed then.
Yep.
What if I'm married? Is there any wisdom or benefit to buying a rental property in joint names with my spouse, or just in my spouse's name or my name?
So, to start off with, even if you're married, I'm going to push you towards forming one of those corporate entities. If for whatever reason you say no, then I'm going to recommend that if you're married, that you don't own this rental property in both names, that you pick one spouse or the other to own it. The reason being is that, again, going back to that potential for liability, so someone slips and falls on the property that you've purchased and own as husband and wife. If you own it as husband and wife and they sue you and they get a judgment, they can go after husband, they can go after wife, or they can go after husband and wife's assets owned together. So everything is on the hook there. Now, if you have one spouse own it, that spouse, unfortunately, his or her personal assets in their name alone would be liable to that judgment. But there's some protection that's available for assets owned by the other spouse, as well as assets owned together as husband and wife.
Yeah, well, that makes sense, because most married couples most married couples have most of their assets in joint names, if not almost all their assets in joint names.
Absolutely.
Their residence, bank accounts, investment accounts, etc.
Yeah, I mean, I think about my wife and myself. I think I've got a couple bucks in my wallet, and that's probably about the only thing I own in my name alone. Everything else is jointly. So to use that as a hypothetical, if we owned a piece of rental property and we got sued and got a judgment against us, everything we own is going to be subject to that judgment.
So if someone wants to do this without forming a corporate entity and they're married, they they really should buy it in their name only. That can be kind of an unpopular thing to go back to your spouse and say, honey, I just got back from the attorney's office. The investment property we're buying should be in my name only.
It can be, but you've got to weigh that conversation against the potential conversation that you have with me at a later date saying, okay, let's go over your options now that you've been sued.
Oh, that's a good point, yeah. So you upset your spouse at the beginning, but you protect the assets, or you keep your spouse content at the beginning and then later on have to have that tough discussion with your attorney. Okay, Jim, good. That's a good thumbnail sketch of the different options people have with buying residential real estate. What I like to do is, on the other side of our break, let's talk about the practical benefits and difficulties of buying real estate investment properties in a corporate name. Mm-hmm. And also we'll talk about the practical difficulties and the costs of taking a property that our viewers may already own in their individual name or in their spouse, or in joint names with their spouse, and converting it or transferring it into a corporate name. So folks, stay tuned. You're watching Legal Talk, brought to you by the law offices of O'Donnell, Weiss, and Megay. We're at 41 High Street. Sorry, 41 High Street in Pottstown. We've only been there 60 years, and I've been there 24 years. Or 347 Bridge Street in Phoenixville. It's www.owmlaw.com. Your life, your business, your law firm. Please stay tuned for the second half.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Welcome back to Legal Talk show brought to you by the law offices of O'Donnell, Weiss, and Megay. Your life, your business, your law firm. I'm David Megay. I'm one of the attorneys at the office, and I'm joined tonight by Jim Kovaleski. And folks, if you're just tuning in, on the first half of the show, Jim led us down the path, if you will, of the pros and cons of different ways to own investment properties. Halves of doubles, 1 unit, 2 unit, residential, rental units. We really didn't talk about larger commercial properties, but your concepts that you talked about apply to the commercial properties as well as to the residential rental properties.
Absolutely.
But folks, if you missed that, hopefully you'll catch the next time the show airs, the first half of the show. The second half of the show, Jim, I want to talk about, okay, we've formed a corporate entity, whether that corporate entity is an LLC or a limited partnership, and now we're ready to go out and buy real estate. Jim, you've gone out and you've negotiated an agreement of sale, the terms of an agreement of sale to purchase the property, and you have this corporate entity that your attorney helped you form, and you have the agreement of sale signed, and assuming you're not going to pay cash for the property, the deal, that's where you were going. I could tell in your eye you're going to say, it's okay, Dave, if you're paying cash. But if the deal's contingent upon you getting financing, what should you do after that agreement of sale is negotiated? And frankly, maybe even beforehand.
I would probably say beforehand, if you're looking at and buying a piece of property, whether it's an investment that's half a double or there on up, probably one of the first conversations you should have at that point, but definitely after you have the signed agreement of sale, is with your banker of choice, whoever's going to be helping you to finance this purchase, to find out what their requirements are. Because we've seen it, and I know you've seen it probably a lot more than I have. Some bankers don't even want to be involved in a transaction. They don't want to loan to an LLC or whatever corporate entity you have selected to purchase this real estate. They only want to lend to the individual. And I've heard many reasons why. Probably the best one that I think I've heard is that they want that individual to be personally responsible for the loan and have, to use one of your terms, skin in the game with this property, so that they know that they're really going to, the bank knows that the owner's going to take care of it, make sure that they get good tenants in there that are going to take care of it. Mm-hmm. But in that conversation, you want to have that up front, because oftentimes what will happen is, if they say yes, if the bank says yes, they're going to say, we'll loan to the LLC, we'll put the name of the loan will be to the LLC, we'll allow the LLC to own the property, so that the mortgage that goes to the bank to secure the loan will be in the name of the LLC, which is a good thing for the personal liability that we talked about in the first half. But they're going to say, Mr. and Mrs. Lender, if it's a husband and wife, we want you, both of you, to personally guarantee the loan.
Or Mr. and Mrs. Borrower.
Yes, I'm sorry, I said lender. Mr. and Mrs. Borrower, we want you to personally guarantee the loan. So what does that mean? That means that the LLC, and I keep, just for ease of reference, using LLC, buys the property. They're the one that gets the loan. So it's the first person responsible on that loan. But anybody that guarantees it, they're also responsible for it. So that if the LLC defaults, doesn't make the payments because the tenant's a bad tenant, or can't find a tenant, or whatever the case may be, well, they're going to look to the bank's going to look to the LLC first, and then they're also going to look at those personal guarantors and say, hey, I know you've got money. I want you to step in and make good on this loan for the LLC. So you might be able to get the loan. Chances are you will be able to get the loan, but number one, you're probably going to get a bank requirement that you have a personal guarantee. And the other thing I often see is that you might have to pay a little bit higher of an interest rate. They might be able to give you a lower interest rate if they're lending, the bank will if they're lending to an individual than an LLC. That one I don't know. I don't understand why, because if you get the personal guarantees, it's just like loaning to the individual. But
Yeah,
we've seen it.
Yeah, we sure have. I've never understood that. If I have Megay LLC as the owner of the property, and then David A. Megay signs a personal guarantee guaranteeing my LLC's performance, how's that any different than me just owning the property? I don't see the difference, but our banker friends tell us that, and I don't quite understand, but I guess there's portfolio requirements that they can only have so many loans to small businesses, corporations in their portfolio, and they can only have so many. And the more, if they have too many, it does something. I don't really know what it does, quite frankly. But I think the moral of the story here is folks, before you even incorporate to buy real estate, go speak to your favorite lender, and then maybe speak to one or two others, and find that lender that's most user friendly when it comes to buying residential rental units. Find that lender that is most flexible, and find a lender that will loan to your LLC, albeit with your personal guarantee, like you talked about.
Absolutely, and that's a great point to go to a couple different ones, because I've found that different lenders have different types of appetites for the types of loans that they are willing to make. Some will loan, will be easier to get a loan for a residential mortgage for your primary residence, whereas the next one, they might have different terms and worse terms for that, but they'll be more than happy to loan your LLC at a more favorable rate to purchase a rental property. Again, it comes back to the way that they look at their risk and how they evaluate that and what they're willing to put out on the street.
Yeah, now that I think about it, and as we talk, I really think it is very important for our viewers to go speak to their lender first, or lenders, and find out what their appetite is for loaning to a corporation that's going to own that 2-unit rental property that you're looking to buy. Do that first, and if you find a lender that says, yeah, sure, it's going to be a little bit more expensive interest rate-wise, to do so, but absolutely we support you going out and incorporating and buying in the corporate name. That's the lender you want to deal with.
Yeah. And one more point on that,
Sure.
higher interest rate. To me, I've always explained it and looked at it as it's just like purchasing additional insurance, and that's essentially what you're doing. It's a cost of owning that real estate. It's additional insurance to help avoid some of that personal liability. And to my clients, I think it's well worth it, whatever it is.
Good. All right. Let's say Jim, that your client did what we just suggested, and they go to the bank, and the bank really throws a wet blanket on buying it in a corporate name, and because they don't want to loan to a corporate name. So the person comes to you and says, Jim, I bought this property already. Shame on them. They should have talked to you before they bought it so you could walk them through it and help them. But let's say they do it, and then later on they come to you and say, you know what, I read in the newspaper, or I read in a magazine, or I saw on TV where I should transfer this into, or my cousin did it, transfer it into a corporate name. What are some of the pros and cons of that?
So the pros go back to the reasons why you would start off with a corporation or an LLC, the personal liability protection. I mean, that's probably the biggest pro out there. So the cons is it's going to cost you. You're going to re-incur some of the fees that you paid when you initially purchased it in your name, and you're going to have to essentially pay them twice. Those fees are the cost to prepare and record the deed, because you already paid that once when you purchased the property.
So I'll be preparing a new deed from Dave to Dave's corporation.
Exactly.
So I got to have someone prepare it, and I got to pay to record it at the county.
So that's a couple $100 at least right there.
Right.
The bigger fish in this whole, the fees, as far as the fees go, is the realty transfer tax. In Pennsylvania, in most jurisdictions, if you buy or sell real estate, there's going to be a 2% realty transfer tax. That actually can go up in some of the cities and some of the areas where they've elected to have a higher one. But 2% on, let's say, a $100,000 house, that's a $2,000 hit that you've already paid once. Actually, you didn't pay a full thing, because when you bought it, you probably paid half of that, because usually the buyer and seller split that. But if you're transferring it from your individual names into your corporation, you're on both sides of that transaction, so you're going to essentially pay it 100%. So you're going to pay, again, to $2,000 on a $100,000 house in most jurisdictions. So you're going to have those initial costs of recording and preparing the deed, the realty transfer tax, and then you might even end up in a situation where you have a bigger fee to pay, or a bigger amount to pay, I should say, because when you've got that original loan and the bank gave it to you and your spouse, and then you transfer it to your corporation, chances are that if you do that without the bank's approval, and the bank's not going to approve it, I just haven't seen it, you're going to violate what's known as a due on transfer clause that are in most mortgages and notes. And what that means is that the bank finds out about it, the transfer, because you've transferred it from the original owners to this corporation. They have usually the right to accelerate 100% of what's due on the principal plus whatever interest has accrued. So you might get a letter one day saying, we saw that Mr. and Mrs. Smith, you've transferred it to Smith Inc. We're accelerating this mortgage. Pay us in 10 days or 30 days, whatever the note or mortgage provides for. And that could be a big shock for individuals.
Yeah, that can be, especially if interest rate is going up. Now, I can just go out and get another mortgage and refinance it, but then I've got to pay those costs associated with it.
Yep.
But, Jim, back on that transfer tax, that 2%, but I'm selling it to my corporation for $1.
It doesn't matter. Pennsylvania looks at that as a transfer between two distinct individuals, because there are some exemptions to the realty transfer tax, but that's not one of them. And they say that if you use $1 as your consideration, they say, no, that's not what the property is really worth. We have this thing out there called the assessment, and we have this thing called a common level ratio, which is a factor that Pennsylvania Department of Revenue puts out every year for each county. And what you do is you take your assessment, multiply it by that common level ratio, whatever it is for whether the property is located at the county where it's located, and then that spits out a value. That's what Pennsylvania is going to say is the actual fair market value for the property, and that's what you're going to pay the 2% on, not that $1 that you put in the deed.
Okay, so my attempt to do an end run around the my lender who wouldn't loan to my corporation, so I say, fine, I'll buy it in my own individual name, and then I'll flip it to my corporation and thumb my nose at the lender. That thumbing of a nose costs some money.
Costs some money. It's probably going to cost some heartache and some stress
to
get it done.
Okay, but I've had people do it.
Absolutely.
Okay. Now we've just got a little bit of time here, about 2 minutes, but I just thought of something as you were talking. What if I form a corporation and I buy the property in my own individual name, or my name and my spouse's name, and couldn't I use that corporation to quote-unquote manage the property?
You can, and what that does is it puts a level of essentially puts that corporate entity between you and the tenant, so it probably provides some protection there. At the end of the day, though, if I slip and fall, if I'm a tenant or a guest of the tenant, I slip and fall, I'm going to look at, okay, well, the corporation loaned it or rented it to me, but I want to make sure that the corporation owns it. Going to do my due diligence, find out that the individual owns it, and then I'm going to just sue everybody basically in my complaint. So.
Okay, so yeah, if I fall, I would sue the property owner, which is you individually.
Yes.
And I would sue my landlord, which is the corporation, my management company, on the lease.
Yes.
But it's better than me being on the lease personally, though, right?
You
or
get
my spouse and I.
Absolutely. I mean, you get some that level of protection in between. You get some anonymity because they're dealing with the corporation rather than you individually. So there are some benefits to that structure.
Okay. So there's some end runs we can do that cost some money, but we can talk to you about it, folks. There's also some alternatives that we can use, so maybe some hybrids, some best case scenario type arrangements to protect you from liability. But there are options out there, and we'd like you to consider us and think about us and give us a call to talk about those options when it comes to buying investment properties, rental properties. But Jim, thank you very much. I appreciate it.
Thank you,
and
Dave.
I appreciate you walking through our viewers through the different corporate entities, and then of course the consequences of transferring properties and the options that are out there. Folks, please tune in again. You're watching Legal Talk, brought to you by O'Donnell, Weiss & Mattei Law Offices. This is our 60th year, by the way. We're at 41 High Street in Pottstown, 347 Bridge Street. In Phoenixville, our phone numbers are 610-323-2800 or 610-917-9347. Finally, it's www.owmlaw.com. Your life, your business, your law firm. Thanks for tuning in, and have a great night.